Good evening. Welcome, everyone. Thank you for joining us tonight. My name is Jenny Mattingley. I'm the Vice President for Government Affairs at the Partnership for Public Service. For those of you not familiar with the partnership, we're a nonpartisan nonprofit working to build a better government and a stronger democracy. One of the ways we do that is by convening conversations like this one to help support the federal workforce. And we know many of you are here because you have a lot of questions about the probationary period, your status, appeals rights, and just trying to make sense of some of the actions that have occurred over the last few weeks. Tonight, we'll dig into different types of probationers, different considerations for each, and we brought some guests on to help us walk through those things. We really are here to support you as best we can through resource sharing, plain language explainers, and really just making sure that we're lifting up the stories of the incredible work that federal employees do for the country. So first off, I want to start by thanking all of you for your service. With that, I'm going to make a few quick house, and then we'll dig into today's webinar. Just a quick disclaimer, the content provided during this session is for informational purposes only. It's a general overview and provides some of the typical processes around various employee actions. It's not intended to provide legal guidance. If you require legal advice, we recommend consulting with a qualified attorney who can assess your unique circumstances. Throughout the webinar, you will be able to ask questions. We will try to answer those that were submitted ahead of time, but you can also submit a question anonymously through the Q&A function, and we'll work to get through those as well. Unfortunately, we won't have time to answer every question, but we are going to record this webinar and post it on our resource hub. So we'll certainly have other resources out there as well, and we'll share, excuse me, I can't speak tonight. We'll share some throughout via the chat. And just a reminder, this discussion is geared towards federal employees, but it's an open forum, so we may have folks joining us from the media, other communities, but it really is information geared towards federal employees this evening. And with that, I'd love to introduce our guests tonight. Could you please briefly introduce yourself, and then we'll jump into the questions, and maybe we'll go order of how I see you on my screen, which is Jim and Bob and then Rob.
Okay, I guess I'll go. Thank you, Jenny, and thank you for the partnership for hosting this. It's an important topic, as are many of the topics regarding federal employees over the last several weeks. My name is Jim Eisenmann. I'm a partner in the law firm Alden Law Group, who primarily represents federal employees.
Yes, thank you, Jenny, and it's great being here tonight. My name is Bob Erbe. I'm in private practice currently, exclusively representing federal employees. Prior to going into private practice in 2015, I was an agency attorney for a number of federal agencies for 20 years, and practiced before the MSPB, EOC, and FLRA.
Hey, everybody. Thanks, Jenny. I'm Rob Shriver. I'm the Managing Director of Democracy Forward's Civil Service Strong initiative, which provides resources and assistance to federal employees. Up until January 20th, I had been at OPM for the entirety of the Biden-Harris administration, serving the last 8 months as the Acting Director of OPM. Nice to be here.
Great. Thank you all for joining. A lot of experience on the webinar tonight with the issues we're talking about. So really thought we would start with setting the stage for folks. I know a lot of the people listening were probably in probationary status, but they may not be familiar with either their particular status or the other, other types of probationers that might be out there depending on where they've come from and at what levels they're serving. So would love to dive into just an overview of the probationary period and really who might be on probation, just to set the stage. And Bob, do you want to jump in, and then we'll invite others?
Oh, sure. I mean, the probationary period is supposed to be the initial period of opportunity for an agency to evaluate an individual's performance as to whether they should be considered permanent as a permanent job. So it's generally a 1 to 2 year period, depending upon how they were brought on board, their nature of their appointment. But one thing people have to keep in mind when we're talking tonight with civil service protections it's not whether or not I'm serving a probationary period, it's whether or not I'm an employee as defined by 5 USC 7511. So as we'll get into detail more about that, that's really what the focus is on, because if you are an employee under the statute, then you have civil service protections, due process, and a right to appeal to the MSPB.
Rob or Jim, do you want to jump in? Because I know some people might be saying, well, I'm a new manager, or I'm a new senior executive, or I'm accepted service. There are different places where an employee might be on a probationary period, but it could be different, to Bob's point.
Sure. I did forget to mention that I worked at the MSPB for about 8.5 years. I did neglect to mention that little factoid.
Good, helpful detail.
So, and yeah, I agree with everything Bob said. You know, depending on the whether you're in the competitive service or the accepted service, the length of the probationary period might be 1 or 2 years. The accepted service, they tend to call it a trial period as well. But I think really one of the important things to think about is, do you meet the definition of employee under the statute, the law that Bob mentioned? Because there are times when, you know, if we start with the basics, that someone in a probationary period or a trial period typically would not be entitled to any kind of notice and an opportunity to respond to any kind of notice that an agency wants to fire you. Whereas people who have passed probationary or trial period would be entitled to that. So sometimes agencies do get this wrong. Sometimes people have made it past the 1 year or 2 year mark. Other times people can kind of combine service to meet the 1 or 2 year period. So it's always important for an individual to understand, well, maybe I do meet this definition of being an employee, and therefore do have these due process rights. And sometimes it's very easy. Maybe you've never worked in the federal government ever before, and you were there for 2 months. It's probably going to be that you're not an employee for purposes of kind of having appeal rights or due process rights. But again, it's really important to pay attention to whether you do meet that definition, which requires understanding, all right, what was my job, hoping that you had your last, well, hopefully all, but at least your last several SF50s that tell you a lot about the job you're in and the authority under which you were hired, which also can tell you a lot about whether you're going to meet this definition of being an employee. So I hope that dealt that.
And Jenny, could I just add, like, let's also just be clear, because people might not be familiar with the terminology. Being a probationary employee doesn't mean that anybody's done anything wrong. You know, they think about probation and maybe think somebody did something wrong and they're put on probation. That's not the case. These are people that are new to their positions, new to the government. Being on a probationary period doesn't mean that you're fresh out of school necessarily. It might be, but you know, we hired a lot of senior AI talent in the federal government in the last couple of years, and those folks with like storied careers in the private sector could be on a probationary period. And just the third thing is, these are not political appointees. These are not Biden era political appointees. These are people that are career feds that went through the regular merit-based hiring processes to get into their job. So when we're talking about probationary employees, that's who we're talking.
Thank you. Those are all helpful clarifications. And also, one of the questions I've heard folks say is, a lot of folks have moved from a career in civil service at the GS level or another accepted service into the career senior executive service. And then that clock starts again with a probationary period. And I've had a lot of employees ask, if I am in the SES, does that mean I'm under the same type of probationary period as somebody who's new to government? Bob or Jim?
Yeah, I mean, when someone goes into the senior executive service, they're going to have I believe it's a 1 year probationary period. Same thing with the first time you become a supervisor, you're under the statute, you have a 1 year probationary period. And whether or not, depending if in the same agency, you get promoted to the supervisory position and you pass that supervisory probationary period, there are circumstances where you can return back to your previous position.
Yeah.
But if you went to a different federal agency as a brand new supervisor, you wouldn't necessarily have return rights back to that former agency.
Yeah.
So those people are also serving a first-year probationary period as a supervisor under the statute and regulations.
Yeah. Yeah, that's a great example, Bob. So yeah, so if you stay in your agency, if you're a GS 13 budget analyst, and then you get promoted to be a GS 14 supervisory budget analyst, you're going to be in that supervisory probationary period for that year. And you could come back to your job if your performance as a supervisor is not up to the standards that the agency has.
And if I'm understanding correctly what you said earlier, just to clarify for folks, in that case, if somebody has been an employee under Title V for, years of their career before they became a supervisor, they would still be covered under appeal rights.
Yeah, generally, I think that's correct. Yeah.
Okay. So, well, why don't
as long as they didn't, like Bob said, as long as they didn't go to a different agency.
Okay. And so if they move to a different agency, the clock starts potentially over again.
Yep.
Right.
Okay. That's helpful, because I know that's a question I've gotten from a lot of folks, because it creates, like everything, it's complicated. So keep telling folks it's, this is why there's confusion out there, because it's not a straightforward system here. One of the things you mentioned is the SF50s. Will that tell folks if they are in a probationary status and help them figure it out? Or is it something that they need to come talk to somebody about? How would they go about figuring out where they fall in this category?
I think, first of all, any federal employee right now on this call, if you have access to your EOPF, you should download the entire thing. So you have your records. This is particularly important, number one, to Jenny's question, helping to determine, looking at these SF50s, whether you're a probationary employee or not, but also, unfortunately, with the fact that wholesale reductions in force might be coming, having your history of your jobs is important as well. But the SF50s, the appointing SF50 and really other SF50s after that are really important in terms of helping to determine whether you are going to be in a probationary period or not, or whether you've reached that plateau or past that plateau, where you're an employee under the statute, which entitles you to due process rights.
Right. So the SF50, the appointment SF50 that Jim's talking about, is that sometimes in the remarks section, it will say individual serving a probationary period for 1 year or a trial period for 2 years. It'll say that in the remarks section, but it might not say that at all. But they could still be serving a probationary period. And so the case law is that the SF50 is not a legally controllable document, meaning it can't confer jurisdiction upon the MSPB. So there could be errors in the SF50. And that's like what Jim was saying, you really need to examine all the SF50s and look at all of them and kind of piece all this together to determine whether they're employee and whether they have appeal rights.
Thank you for going through that, because I think there are probably a lot of folks on the phone who are on the webinar who are parsing through all of this.
I'm sorry, and let me just add one more thing. And just because the remarks section might say you're serving probationary period or trial, that doesn't necessarily mean it's correct either.
Right.
And there can be issues when people are serving term or time limited appointments, and so you really have to look at each of these very, very carefully.
Rob,
hey, Jenny.
go ahead.
Yeah, could I just want to clarify something, because I'm seeing some confusion in the chat here. So I just want to, when Bob and Jim are talking about whether you qualify as an employee, they're talking about a very specific statutory provision that grants appeal rights to the Merit System Protection Board if you're subject to an adverse action. That's the narrow context they're talking about it in. That doesn't mean you're not an employee of the federal government for all kinds of other purposes, including getting paid, earning leave, everything else. You are an employee of the federal government. You get a W-2, you're not an independent contractor or anything like that. It's just for this one specific statutory provision. They have a definition of employee that says that you basically have to have your year. So I just saw a few questions on that. I wanted to try to clarify it.
That's great. Thank you. And that's really what most people commonly understand with the probationary period, is that 1 year mark after you sort of gain tenure, so to speak, in terms of appeal rights conferring to you, or longer if your probationary period is longer at certain agencies. So thank you for clarifying that. Why don't we jump into, now that we've talked a little bit about what the probationary period is, what happens typically? What's the termination process? Because a lot of folks have experienced this, and there are questions around, do they get notice? What happens when a probationer is let go? And, this happens across agencies all the time. We've just seen it at greater scale right now. So I'll throw that out there. Jim or Bob, can one of you walk us through what happens if somebody's terminated?
I'll let you handle that, Bob.
Okay. Well, typically, again, it depends upon their appointment, competitive versus accepted service. However, generally speaking, because if they are serving a true probationary appointment and they're not an employee under Title V, generally speaking, from the agency's perspective, it's a one-step letter. You are terminated for performance or conduct. It's a one-step letter, and it could have the appeal rights that if you're a competitive service, you can file, an appeal with the Merit Systems Protection Board if you believe it's based on partisan political discrimination or marital status. If it's accepted service appointment, it might not give you MSPB appeal rights because that's a regulatory right, so it doesn't really apply to accepted service appointments, but it'll tell you your right to OSC, the Office of Special Counsel, EEO, filing an EEO complaint. So generally it's a one-step process. And as Jim will probably confirm, because it's a one-step process, if the agency screws it up and doesn't give the employee due process rights, and they're found to be an employee under Title V and they go to MSPB, it's going to be reversed on a due process violation. So that's where the agency screwed this up. They are rushing. They immediately issue a termination letter. And then they later on find out at the board, oh, this was an employee. They were entitled to the full protection of Title V. Now we have to cancel the action and reverse it. So.
Yeah, I think another way of looking at, especially those of you who worked in the private sector, for the most part, private sector employees are employed at will. And you could almost look at it that way, that someone in their probationary period is in that category. So you could be fired for, the agency doesn't like your performance or your conduct. But they can't fire you for, even if you're in a probationary period, for an illegal reason. And an example of an illegal reason would be if you were fired because in retaliation for being a whistleblower, or you were fired because because of your race or your sex, or in retaliation for you having participated in an EEO process. Again, a lot of what Bob and I do in terms of representing federal employees, sometimes what happens to someone is enough to give them rights to take an action. So as we've been talking about, someone who meets the definition of an employee under this, as Rob was saying, this very specific statute, if you're fired after meeting that definition, then you have rights, period. Doesn't matter why. If you don't, if you're not meeting that specific definition, then your ability to challenge a firing might depend on why you think it happened. That you think it happened because you were a whistleblower, because of your race or your sex or your age, etc.
Thank you for going through that. And I know one of the things that people were seeing, and I've heard questions around, are the idea of being terminated for performance. A lot of folks got letters saying performance, and that's sort of performance and conduct are kind of the two general issues at play for most employees. And it doesn't necessarily mean at the 1 year mark with a performance review. Performance can be broader than that. Is that correct? Because I think I've heard people say, well, I was only in for a while. What does being terminated for performance mean? And what does that confer about the person, in that letter? That might be a tough question to answer, but Rob, go ahead.
I mean, there's one thing that I'll say on this. I don't think there's any requirement that they keep you on a year, right? Like, I think if the whole point of the probationary period is it's kind of a continuation of the hiring process. And, you've gone through, you've applied, you've been deemed qualified, you got interviewed, you got picked. And then the agency gets a chance to see if you're up to the job and if it's a good fit, and if you can do it. And if they determine prior to that 1 year, I mean, you guys are the experts, you should correct me if I'm wrong, but I don't think they got to keep you around for the entire year. Now, the problem is, like, it's got to be based on your performance or your conduct, and not on somebody's perception about government employees in general, so to speak. Or based on some desire to restructure the workforce. Like, that's where the problem is this whole probationary period exists to evaluate you based on your performance and your conduct. And, Jenny and Max at the partnership have for many years advocated that agencies make good use of that probationary period, that managers provide feedback and stay close to employees as they get through, and then make a conscious decision at the end of that year about, is this person really working out? And I think that's all good management practices. And it's because it's all tied to you and how you're performing in the job. That's what's critical.
Jackson, we must have a question. I see you jumping on board here.
Thanks, Jenny. And thank you to everyone who's submitting questions in the chat. We're receiving a lot of them, so we're going to try to answer as many as we can, but we will work on getting those some FAQs online afterwards for those we can answer. So part of this conversation, we're talking about termination for performance. And we've had quite a few folks in the chat say, hey, I was terminated, but I was winning awards. I got excellent performance reviews. And first of all, congratulations to those individuals. Thank you for the work that you did to earn those awards and those reviews. But then they're getting a termination saying it was for their performance. Can any of you maybe just walk through, what that means, what might be happening there, and if there's any recourse for those individuals, knowing that they have a paper trail of good performance on their record?
Yeah, that's obviously happening a lot, and we get inquiries and emails from a lot of federal employees saying exactly that. Like, I just my boss just told me I excelled at every part of my job and I'm doing a great job, and got a quarterly review that was excellent. To me, that shows that the kind of mass terminations of probationary employees is really a disguised reduction in force. And a reduction in force requires some good deal of process to do that. So the notion that you're getting this notice saying your performance or conduct was not acceptable or wasn't what we need, or et cetera, to me, it just shows that the whole process of letting these probationary employees go in that way is a sham. Now, of the thousands of people that probation employees that are being let go, or hundreds, I'm sure there are a couple of people that fit in that category, that there's maybe their performance is not where it should be. But by and large, everyone's just getting these notices saying it's cookie cutter. That's what it is. And and we can talk about this. The government sometimes does reorganize and wants to change how particular agencies run or focus, the types of things they focus on. And maybe at times there's too many people in a particular office, and that happens. But here it's just a wholesale, let's get rid of these probationary employees because we think they have no rights.
Yeah, I'm not sure exactly what was the reasoning behind putting it to performance or, performance issues, but I mean, some termination letters I've seen so far said to you're being terminated because your retention is not in the best interest of the agency. So it's not saying it's performance, it's just saying it's not in the best interest of the agency. At least those employees are like, well, they're not attacking my performance. And I don't know. I mean, it will be interesting to see, if these individuals, like Jim was saying, believe they were fired for an illegal reason and pursue that. And they say, well, wait a minute, I had all these great performance reviews and they said it was a performance issue. So why did they fire me? And then someone's going to have to testify, well, it wasn't because of your performance, it was a cookie cutter letter or something like that. So it's going to cause a little bit of a mess if it goes into one of these other bodies, the EOC, MSPB through a whistleblowing allegation, or USERA, military status discrimination for all the veterans that might be being terminated. If they allege it was because of my military status, and then go to MSPB, the agency is going to have to articulate a legitimate non-discriminatory reason for the terminations, and they're already kind of in a pickle because they have this inconsistent evidence.
That might be a good place to take a step back for a moment. And we've talked about the different, you mentioned USERA, we have OSC, EEOC, MSPB, kind of an alphabet soup of some of our administrative forums there for these cases. It's probably a good time to take a step back and talk about what each of those, you mentioned it a little bit, but talk a little bit more in detail about what the appeals process is to these different forums. And also one of the things we haven't mentioned too are for employees who might be under a collective bargaining agreement as well. And that's going to be a little different. So maybe we'll tackle first, the collective bargaining piece, and Rob, Jim, Bob, I'm not sure who wants to jump in, but that's going to be different for employees. At least my understanding is, and then we can jump into what an appeal looks like at each of these other forums.
Yeah, I can start with the union one. If you're a probationary employee and you're subject to termination, you may have rights under your collective bargaining agreement. If it's based on one of these impermissible reasons, it really is best to check with your union representative. Sometimes the contract can provide rights for you to vindicate. You would vindicate them through the grievance arbitration process. So it's a whole different process. The union would represent you in a grievance arbitration process. And the way that goes is there's usually an internal process to the agency first to bring the claim to them. If it's not resolved through that, then the union has the ability to appeal it to arbitration. And then those arbitration decisions, and an arbitrator is a third party neutral. There are a panel of arbitrators that the union and the agency select together. So you have these third party neutrals that can rule. And then the claims can go up to the Federal Labor Relations Authority on sort of like appeal from an arbitrator's decisions. So that's like a whole other separate path. And probably Jim and Bob can talk more, but it's important to have these conversations at the outset, because there are election of remedies provisions, and basically if you choose to go down one path, it can foreclose you from other potential paths that Jim and Bob can talk about too.
Yeah, that's important to have an understand. I think this is why having these is important, to understand what your rights are in the first place, and also really understanding what the deadlines are, because typically with claims under a collective bargaining agreement, sometimes initiating that grievance process is a very short period of time. It can be 10 or 15 calendar days, versus say someone who has the right to file with MSPB, you have 30 calendar days, or initiating an EEOC complaint, you have 45 calendar days. Then you have the Office of Special Counsel, which Some people think there's a 3-year statute of limitations, but much longer period with OSC. I'll touch on the MSPB. If you have the right to file an appeal to the MSPB, you have 30 calendar days from the date of whatever the action is. So if you get fired today, you've got 30 calendar days from today to file an appeal. MSPB has an e-appeal system. You can file appeal electronically that way. It's typically relatively easy. You don't have to have a lawyer to do that. You can do it yourself. Once you file the appeal, then an administrative judge is assigned to your case. You'll get an acknowledgement order from the judge that tells you kind of the processes that are going to happen. And ultimately, if you want a hearing before the judge, you will have a hearing before the administrative judge. The process can take 4 months, 5 months, 6 months. The judges have a goal. Sometimes it's in their performance standards, sometimes not, of issuing decisions within 120 calendar days of the date you file the appeal. Some cases are more complicated than others, and it takes more time. But that's just to give you a general idea. The MSPB process also permits for discovery, meaning you can ask for documents from the agency or send interrogatories or take depositions. And then once you have the hearing, the judge will issue a decision. That's a very thumbnail description of the MSPB process. So I'll turn it over to Bob.
And Bob, do you want to walk through anything to add to that, or walk through the OSC process?
Sure. The OSC process is dependent somewhat on, so if the employee believes the OSC has jurisdiction over prohibited personnel practices. They also have jurisdiction over USERRA, which USERRA, it's Uniform Services Employment and Reemployment Rights Act, that prohibits discrimination based upon military status. So an employee could go to OSC with a prohibited personnel practice or USERRA complaint. But as Jim mentioned, they don't have to go to OSC first. They can go to MSPB first without going to OSC. But let's focus on the prohibited personnel practices. The employee would file a complaint with OSC. That's also a fairly easy process. It's online. I file a complaint. There's, I think, 14 prohibited personnel practices. And so they'll file a complaint. Now, if the complaint involves what Jim mentioned earlier, whistleblower retaliation, then OSC will look at it. But in that limited case for a whistleblower retaliation, at the end, if OSC doesn't take action, at the end of that investigation, OSC will give that employee an individual right of action letter to go to MSPB. Now, that's only for whistleblowing. So if it's another prohibited personnel practice, then OSC will keep it, and then OSC will decide whether they will take the case to the MSPB on behalf of the employee. But only in whistleblowing does the individual get an individual right of action for themselves to go to MSPB without OSC's involvement.
Thanks for walking through each of those. One of the questions I think we're getting is a clarification question on some of the windows, because obviously folks are already within some of these windows. You mentioned, Jim, the 30-day window for filing to MSPB, calendar days, not work days, correct? Okay. Calendar days, to make clear. And one of the questions, or a couple that we're seeing, are about whether the date starts when the agency takes the action. What if the employee doesn't get the notice right away? So there's some confusion around that.
Yeah. So if you're getting notice by email and your email address is up to date and you have access to the email, for example, they send it to your and you have access to the email, generally, if you're not looking at it, you're not looking at your email, sometimes can be very difficult to say, well, I didn't get it. And if you miss the deadline to file the appeal, you may be out of luck. But the 30 days starts from the effective date of whatever the action is. So a firing, you may get notice, for example, you may get notice today that you're going to be let go effective March 3rd. So that time period, the 30-day time period, doesn't start to run till March 3rd. And you would start counting from that point.
Including if you're put on admin leave too, right, Jim? Like that's a question here about being put on administrative leave. I mean, I guess if we found it hard to be able to challenge that action of putting somebody on admin leave.
Yeah.
If you found a way you want to challenge that, then your 30 days would start when you were put on admin leave. But we don't see much of a claim there. So it's more whenever the admin leave ends and you're terminated, that's when the 30 days picks up.
Right. And correct me if I'm wrong, but Jim, so I had a recent client reach out to me, and she received her termination letter on February 14th, say. However, it wasn't effective until March 14th. So the agency was kind of being somewhat gracious and giving her 30 days before the effective date of her probationary termination. This individual actually, though, she was actually an employee under Title V. She actually had prior federal service that she can carry with her. She tried to contact her HR department saying, "You got this wrong. I am an employee. You screwed up." So she reached out to me, but what we were going to do was file an MSPB appeal now because she's got served with the letter. Now, Jim's right. The 30-day clock to run starts on March 14th. But that individual can file an appeal now, so they don't have to wait to get the adverse consequences. Now, luckily for this employee, today she contacted me and HR recognized the problem and they canceled the action. So she doesn't have to file an MSPB appeal and everything's been taken care of.
That's a great example, Bob, because I think that's important, again, for all of you to be able to download your EOPF. That can be really helpful, especially dealing with HR, and you being able to say to HR, "Hey, look at this SF50 that I have that says this," or explain it. Now, that's great that this agency corrected the mistake. Not every agency is going to do that. And Bob's right. You don't have to wait. You have notice. You don't have to wait until the effective date to appeal. And that's kind of a strategic decision too. I would have done the same thing, file an appeal before the effective date. Yeah.
And so in terms of, what employees can look for, we've talked about the SF50. I think we've put some items in the chat about filing themselves for MSPB. Can they self-file as well for OSC, Bob? Or is that?
Yeah, I think so. Yeah, I think it's self-file. It's on the OSC website. I think it's a big box that says file a complaint. So they can self-file.
And what types of, I know it walks it through, but do either of you for MSPB or OSC have any sense of what sorts of materials an employee would need if they're going to self-file? They probably need their termination notice and potentially their SF50 or something that shows. So to make sure they're downloading not only their SF50, but keeping copies of any notices they receive.
Right. Yeah, I mean, they need the termination letter to upload to the MSPB system. But I'm sure Jim will mention this too. But once they file the appeal and they have the termination letter, so the judge will issue an acknowledgement order giving the agency 20 days to file an agency file. So say if the employee doesn't have the SF50, they don't have to wait and say, "Oh, I don't have an FF50. I'm going to do a FOIA request to get my SF50." No, the agency will have to produce that evidence to the judge as well to prove that the board doesn't have jurisdiction one way or the other. So they just need the termination letter. If they have the SF50, that's great. The board's going to ask for that to upload it, but they don't necessarily need it.
Yeah.
That's great. Are there other things, resources, things employees who are on probation thinking about these issues should be thinking about right now in terms of where they can look for more information or, how they go about finding? I know one of the questions we get a lot are or how do you find legal support? Are there class action lawsuits? There's a lot of questions swirling about where else federal employees can turn for resources out here. And Rob, I don't know if you want to jump in on that.
Yeah. So, I mean, first of all, there are websites out there like our website, civilservicestrong.org, that provides resources to federal employees trying to make sense of all of this stuff. And we do have some FAQs up there on probationary employees, and I expect that we'll be including more information very soon. There are actions out there that are pending right now that probationary employees should be aware of. Jim's firm and Democracy Forward are working on a complaint that was filed on Valentine's Day with the Office of Special Counsel. The complaint alleges that the mass terminations of probationary employees constitute a number of prohibited personnel practices. We filed it with OSC. We asked OSC to pursue a stay while it investigates. So OSC is an investigative body. When you file a complaint with them, they then investigate the allegations, and if they believe that there's a reasonable basis for the allegations and that people are going to be harmed, they have the ability to pursue a stay. They did that on behalf of 6 named employee representatives. And the MSPB last night agreed and entered the stay for those 6 representative employees. So this can get confusing really fast because there's a couple things to be careful about here. So one is, this is a great result to establish a legal principle that the MSPB and OSC see enough here in this claim that these mass terminations constitute a prohibited personnel practice to issue this stay. I have mentioned that it's only issued on behalf of the 6 named representatives. The Office of Special Counsel has indicated publicly that they're interested in a path to broadening the remedies. And so that is something that we are actively working on. And by broadening the remedy, that would mean expanding this stay out more broadly. That has not yet happened, though. So the investigation will proceed, and we will see how OSC engages on this going forward. And it may be that more people, more agencies get covered by a stay, but they're not at this point. We also are collecting information. There is a form that the Alden Group has put together for probationary employees who want to provide us their information in connection with the case. It doesn't mean that you are, if you provide that information, it doesn't mean that you're covered by any kind of remedy at this point, or that you're a client of any of us. It's just important, helpful information as we pursue the case and as we try to expand the remedy, hopefully to include more people. There are other law firms that are putting together cases on behalf of probationary employees before the MSPB. You may have heard about some of those. There will be a legal theory around that those law firms will pursue. I think there's at some point we're going to see kind of how those two actions come together, given that they're related causes there, and one's at the OSC and one's at the MSPB.
And to your point, Rob, some of this takes time to work through the system too. So these, while the forms are relatively quick, so to speak, it still takes months. So Jackson, you have some questions for us.
Yeah, and first I just want to say, because we've gotten a few questions in the chat, this webinar is being recorded and will be available online soon afterwards to answer that. And second, for those who are hearing the chat, We do not have an open chat for everyone to type anything in, but we are receiving all of your questions in the Q&A function. So if you have anything you want to send to us, please send it in the Q&A. So one of the things that I'm seeing in the chat are a lot of questions related to RIF, or reduction in force, and how that impacts or could impact probationary period employees. So my first question to the group is this mass firing of probationary employees we're seeing a RIF? And then secondarily, if not, how are probationary period employees maybe going to be impacted by RIFs in the future?
Great, thank you, Jackson. We mentioned, I know earlier, that there's a lot of process around RIFs, and I know some agencies are getting RIF notices now. Maybe that's a good place to start for probationary period employees who are in an agency. What might they expect potentially with an upcoming RIF?
I mean, I'll just start at the very high level and say it certainly looks like a RIF, and it looks like a RIF that's not going through the RIF procedures. And these guys can talk more, but probationary employees are covered by, right, guys, the RIF procedures that would normally apply. I don't know, like, maybe, tell me if I'm getting that wrong, but normally speaking, if there is a RIF that includes probationary employees, you know, they're part of the overall thing.
Yeah, I mean, when it comes to doing a reduction in force, you know, the agency has to identify something called a competitive area. And it's just a group of jobs and positions that are potentially identified for being eliminated and people being let go. But within that area, so if you think of a competitive area, say, as a particular bureau or division within an agency, and then the employees within that particular division agencies have to put each of those people in something called competitive levels. So if all of us here on the screen have the same job, right, in the same grade level, what the agency also has to determine is how long have each one of us been in this particular job? Do any of us have veteran status? And if you're a probationary employee, if I'm a probationary employee and Rob's been there, you know, 5 years, I'm probably the first one out.
And I think that's the, you know, and there's also, though, with RIFs, there is usually more notice potentially than what you get during what probationary employee have faced right now. Is that correct? Usually there's is it 30 days, 60 days notice?
Yeah, it's 60.
60. Great.
Now,
Jackson.
there is there was
ahead,
the memo that was issued today from OPM-OMB about agencies conducting reductions in force. And there was some language in there about agency heads being able to ask OPM for a waiver of the 60-day notice. But only one of us here was a former acting director of OPM, so I don't know. I can't speak on that.
And so some of these remain to be, you know, I tell folks on these webinars we've been doing, some of this, you know, we're assessing in real time, and remains to be seen how it plays out. Jackson, go ahead with the next question.
Yeah, so seeing a number of questions in the chat as well from supervisors who are attending this webinar, asking how they can support employees that they put a lot of work into hiring, getting on board, and who are doing great work for them. How can supervisors support employees that work for them that are in their probationary period? And, you know, what can they do in this moment?
That is a great question and a tough question. Rob, go ahead.
Okay, so first of all, just be a good human being. This is hard for everybody, and you know, people's livelihoods are at stake, including the supervisors too. So I know it's particularly hard when you're worried about your own livelihood and you're worried about your teams and all of that. I mean, secondly, like, I don't, you know, if you're up for it, documenting that positive performance experience that you've had with that person. Because what we're seeing through the chat, and we've seen these in these letters, is some agencies are just summarily stating that the termination is for performance reasons. And, you know, I really question the basis behind that on a mass termination basis, and having documentation from your supervisor about your level of performance could come in handy down the road. That's what comes to mind for me, guys. I don't know.
I agree. I agree. I mean, it's very difficult. You're concerned about your own job, but you want to support the people that you've hired and mentored. I think it'd be difficult, but to the extent you can help and document that for that employee, I think that's great.
And I think too, just for those employees who may be now looking for another job, making sure that the people in the private sector, again, understand the difference between what it meant to be on a probationary period, and that just because you were terminated for quote unquote performance, you might still have had excellent performance. And so, you know, supporting people as they're looking for their next career journey too. Yeah. So I know we're getting close at time here, so I do want to just give each of you, before we wrap up, we'll have a quick poll for our webinar participants tonight, and we'll preview some of our upcoming webinars, but just wanted to give each of you space in case there's anything we didn't cover that you'd like to cover, or any other final points.
Yeah, I mean, I just want to mention, as far as you mentioned, Jenny, earlier about resources, I'm going to give a shout out to Jim's prior organization, the Merit Systems Protection Board, which has excellent reports on their website. And the one report I highly recommend, if you believe you're in a situation where you might be an employee, where you have prior federal service and you tack on to your current federal service, there's a report called Navigating the Probationary Period through Van Wersch and McCormick. It can walk you through when I can tack on prior federal service to my current federal service, when I can tack on, you know, the prior federal service to my probationary period. So it can help you understand that issue, that might be able to, you know, you might be able to defend yourself on an action with, you know, without legal help. But that's a great report. I would highly recommend people read that report if they believe they're in that situation.
Thank you for mentioning that, and we just put a link in the chat as well. Great.
Yeah, I agree. I think staying informed as much as you possibly can, because I know sometimes this can be overwhelming, but staying as informed as you can is really important. Looking at different sources and resources, and really thinking through some of this, because it can be complicated. I think, first of all, I want to say thank you for being a public servant in the first place. That is, to me, the highest calling. You know, you could do many things, but you chose being a public servant, and I want to thank you for that. But try to stay informed, maintain good records, get that EOPF before you lose access to it, but stay informed, and I want to thank you very much.
Absolutely. Go ahead, Rob.
Yeah, I'll just echo that. I mean, being the acting director of OPM was the highlight of my career, and it was because I got to be the champion of federal employees every day. That's what I love to do. I've met so many folks around the country who work for the federal government, and I'm trying to explain to people that don't get it, that, you know, you guys aren't part of some deep state sitting around, wake up every morning thinking, how can I thwart the Trump administration? I mean, that's just not what federal employees do. You wake up every morning thinking, how can I help get people their Social Security benefits faster? And how can I make sure that this baby food factory that I'm inspecting is keeping our babies safe? Or how can I move forward with scientific advancement to protect us from disease? How can I be a USAID worker that's overseas combating stuff in other countries, not only to help that country, but to make us safer and healthier back at home. I know that's what you all are doing, and that's the word that we're trying to get out. I'm sorry that this stuff is so confusing. You got to understand that nobody has ever done what is being done right now in this administration. And so there is not a clear answer about go this step, this step, this step, this step. Know that you have a lot of people that are fighting for you and trying to figure all this stuff out to help the most people as we can with the most issues that you're facing. And I'll just end by saying, like, look, the vast majority of the time, probationary employees are out of luck, right? Like, you don't have those MSPB appeal rights unless one of those exceptions apply, and you're generally out of luck. And what we've seen OSC and MSPB do shows that they get it, that something different is going on here and that this needs to be closely scrutinized. And so that gives me some reason for hope. And so thank you again for all that you're doing, and thank you for coming out here to try to understand this for yourself and also for folks that you work with.
Great, thank you all. And that's a good place to then switch to our poll very quickly. We do these at the end of our webinars just for the viewers on the line to just check in and get some feedback on the webinar and look for other topics that you may have questions about and want to hear about. So that poll is on your screen if you just take a minute or two on that. And then before we end tonight, we do have some upcoming webinars for folks based on the questions we've been getting and the issues that have been raised. And so my colleague Haley is putting that on the screen. Hopefully you can see it. It's a little small on my screen, but you can also go to our website, ourpublicservice.org. That's OURpublicservice.org. And that way we have a couple different webinars coming up with some career help navigating. We've had a lot of questions on resumes. We've got some leadership and resilience support. So hopefully please keep sharing with your colleagues and letting us know what we all can do to better help support you. And so with that, I will thank our three guests. This was very, very helpful, and really appreciate you coming and spending time with us this evening. And just a big thank you to the folks on the line as well. So have a great evening.